the University of Law. And my name is MT. I'm from PDVL and will be your host for this evening. Before we begin, a few quick housekeeping notes for everyone. Please keep your microphones muted during the presentation and feel free to drop any questions that you have into the chat box. We'll address them during the Q&A sessions later. Tonight, we are very pleased to bring together a very rare lineup of advocacy expertise, featuring 4 experienced ULaw bar faculty members in one session, each bringing a very different area of advocacy experience. Together, they will be covering advocacy basis, submission advocacy, cross-examination, and mooting, and followed by a live Q&A. By the end of tonight, you will have a practical insights into the advocacy training on the bar practice course and the opportunity to ask questions directly to experts. Before the beginnings of the sessions, let me briefly introduce our 4 speakers for this evening. Beverley, she is the Deputy Program Director for the Bar Practice course at ULaw. She called to the bar by grazings in 2008. Beverley previously practiced as a personal injury barrister, and she has taught on ULaw Bar Practice course since 2016. We have Nigel. He is the Program Lead at ULaw Manchester and also Liverpool campus. He called to the bar in 1994. Nigel practiced criminal law for 20 years, including as a senior crown prosecutor, and now he teaches criminal skills and litigation at ULaw. Helen, she is program lead for the bar practice course at ULaw Bristol campus. She called to the bar in 2007, and Helen has taught across ULaw law courses for over a decade. And now she focuses on criminal litigation for BPC students. Finally, Louise, she is academic manager for the bar practice course at ULaw Leeds and Newcastle campuses. She called to the bar in 2011. Louise has experience in commercial chancelling law and international arbitration before joining ULaw in 2023. It is a strong lineup and very pleased to have all 4 of them with us this evening. So let's get started with our first session. Beverley, please.
Thank you very much. I'm just going to load up my slides onto the screen. Just give me a moment. Hello, everybody, and good evening to you all in Malaysia. Thank you very much for joining us this evening. My name's Beverley Dawes, and as you've heard, I'm the Deputy Programme Director for the BPC, and I'm joined by my colleagues Louise, Nigel and Helen this evening, and we are very happy to be delivering this webinar, an introduction to advocacy, delivered by us here at the University of Law. So thank you very much for joining us this evening. I'm going to start first of all with a brief overview of what we're going to be covering in this session. So this slide here shows you the structure to today's session. So shortly we will be giving you a brief introduction to the BPC that we offer at the University of Law. That's the Bar Practice course. After that introduction, we will be going into our Advocacy Basics series. So we'll be starting off with a section on advocacy delivery. So addressing the court etiquette, tone, pace, style, and delivery. After that, we'll be moving on to the second part of our Advocacy Basics session, which is regarding submissions-based advocacy. So how to approach making submissions, how to structure them, and thinking about skeleton arguments. After that, we've got a fantastic segment on cross-examination, and we will be introducing you to what cross-examination is, effective questioning techniques, and how to get the most out of the witness through your cross-examination. And then finally, we will be concluding with a section on mooting. And some of you may already have some experience at mooting. Some of you may never have tried it before. So we're going to tell you a little bit more about what mooting is and share some top tips with you for mooting. And then finally, at the end, we will have plenty of time for any questions that you have. So in the first part of this session, I'm going to be giving you a brief introduction to our BPC and BPC LLMs that we offer at the University of Law. Starting first of all with our study locations. So we're very pleased to be able to currently offer our BPC out of 8 campuses in the UK, and from January 2027 we will be increasing that to 9 campuses, as we have a new campus we'll be delivering the BPC from, which is at our Oxford Brookes campus from January 2027. So this slide here shows you where all of our campuses in the UK are based. And as you can see, there is plenty of choice for you coming to the UK, depending on what kind of area you want to live in while you're studying your BPC. So you may prefer to be in the capital of London. You may want to go over to the southwest to Bristol. You might want to head to the Midlands, or maybe head further up north to Leeds, Liverpool, Manchester, or our most northerly campus, which is Newcastle. We offer a lot of flexibility in terms of studying the BPC at the University of Law, in terms of not only location, but also study modes and start dates, and also whether you decide to study the BPC on its own or study the combined BPC with LLM. Our biggest intake each year is in September. And in September, we offer a full-time September start program that's currently across all of our campuses. We also, however, offer full-time study modes starting in January each year, when the structure of the January course is the same as the September course, as well as a full-time July course, which is currently only delivered out of our London campus. And the structure of the July course is a little bit different. It is a full-time program, but it's a little bit longer and thinner. So it starts a little bit earlier and spreads out the pace of your studies a little bit more at a slower pace than the September or the January start. We also offer a part-time weekend course, but I anticipate that most of you won't be looking at that, so I'll just focus on mentioning the full-time programs. If you do want to ask any questions about the campuses, then do let us know, and you can find out lots more information on our website at law.ac.uk. We're very fortunate today that some of my guest speakers are dotted all around the country. So Louise has the pleasure of covering our Leeds and Newcastle campuses. Nigel has responsibility in both Liverpool and Manchester, and then Helen is based down in Bristol. So we've got a really good broad range of colleagues here today. So if you do want to ask us anything about our start dates or campus locations, then please do feel free to do so. So what does studying on the BPC involve? Well, this slide here shows you all of the core subjects that you'll study on the BPC. We also offer a combined BPC with LLM. If you decide to study the BPC with LLM, then you would complete all of the core subjects for the BPC, shown here on this slide, and then you would gain your LLM through choosing one of 3 pathways. And I'll tell you a bit more about the BPC with LLM on the next slide in a moment. But the LLM would be in addition to the BPC. So this slide here shows you all of the core subjects that you'll study on the BPC. And for all of these subjects, you will have face-to-face tuition at your chosen BPC campus. You will be in workshop groups. It's a very interactive vocational style of program. So you may be conducting advocacy one day, you may be drafting a document in a different workshop, you may be conducting legal research or preparing for a conference. So it's a really varied program. So you'll have those face-to-face workshops at your campus, but you'll also have access to self-study materials. And these include things like manuals, explanatory notes, practice multiple choice questions, sample answers, handbooks, guides, and more. As you can see, the subjects that you'll study are grouped into 3 knowledge areas. They are civil litigation, criminal litigation, and professional ethics, and then core skills shown on the right-hand side of the screen. And the core skills include oral skills of advocacy, and you'll learn different types of advocacy, some of which we're going to introduce you to tonight. You'll also learn the oral skill of conferencing, which we teach and assess in a criminal context, where you'll learn how to conduct a conference with a client who's been charged with a criminal offence. You'll also learn written skills of drafting, including how to draft statements of case, such as particulars of claim and defences, how to conduct legal research and present this in a written research trail, and use that research to inform the contents of an opinion that you'll learn to write on the opinion writing course. On the litigation programs, you'll learn about procedural rules, litigation process, evidence, sentencing, and alternative dispute resolution, as well as professional ethics, the types of ethical issues that can arise for barristers in practice and how to deal with those ethical issues when they arise, acting in accordance with the Bar Standards Board's Code of Conduct. For all of the subjects shown here on this slide, you'll have a mock assessment as well that will help you prepare for your final assessments. And there's even several opportunities to hand in practice pieces of work, such as your written skills and practice advocacy and conference sessions, where you'll receive bespoke detailed feedback from your lecturers to help you prepare for taking your assessments. I mentioned earlier, we also offer a combined BPC with LLM. This slide here tells you a little bit more about that. So as you can see, there are 3 different LLM pathways to choose from. So you would either choose to complete your LLM by writing a dissertation on a subject area of your choice under the supervision of an allocated dissertation supervisor. Instead, you might decide to gain your BPC LLM through completing 2 optional modules. You can find out more about the optional modules available on our website at law.ac.uk. Finally, you might decide to gain your LLM through completing pro bono work. You'll work on pro bono cases either on your own or perhaps with fellow students in a team under the supervision of our qualified pro bono supervisors. So this is very popular with BPC students who want to put into practice the skills and knowledge they're learning on the BPC and applying it to real life cases involving real clients. You can find out more regarding all of our BPC LLMs on our website again. And if you have any questions about this, then please do feel free to ask. We're going to leave time for questions at the end. So that's a very brief overview of the BPC that we offer here at the University of Law and where we offer it and the different start dates and study modes. If you want to find out more, then do have a look on our website and feel free to ask any questions that you have today. In terms of the application process, you can apply directly on our website. The first stage of the application process is a written application, which will be reviewed and considered by our admissions team. If you have met our minimum entry requirements or are on track to, you will then be invited to attend one of our selection events. And this is our recruitment process for BPC students onto our programme. And this is a fantastic opportunity for you to get some valuable advocacy experience and also interview experience. So it's a good taster and introduction to the bar course, as well as giving you some invaluable practice and preparation for interviews, such as pupillage or any other post-BPC vacancies you might be applying for. There's also lots of financial support available for BPC students at the University of Law, including our advocacy scholarships, and selection events give you the opportunity to compete for those. I don't have time to tell you all about our financial support today because we'd be here all evening, but do have a look on our website because we've got a dedicated scholarships and bursaries page on there with a lot more information regarding all of the financial support that's available for BPC students studying at the University of Law. So I hope that gives you a nice overview of the BPC that we offer here at the University of Law. We're now going to move into the advocacy basics part of today's webinar, starting first of all with looking at delivery. So I'm going to be taking you through this next part. And once I've finished this section, I'm going to be handing over to my colleague Louise, who is going to take you through submissions-based advocacy. So what do we mean by delivery? Well, there's no sort of clear definition for this, but really what we are talking about is the way that you address the court. So it's the way that you make your submissions or you speak to a witness, or you speak to the judge or anybody else in court. And the delivery is very important. Now, of course, in terms of what you are saying, whether that's asking questions of a witness or making submissions to a judge, that is, of course, very important. But it shouldn't be underestimated how important it is the way in which you deliver what you are saying. So, what are you aiming for with your delivery when you are in court? Well, first of all, let's think about manner and tone. It's important to remember that you're in a professional, formal setting. And so your delivery manner and style and the tone that you use should be using formal language rather than informal language. It should be professional language. And that moves us on then to the type of language that you should be using. Well, what you always want to aim for with your advocacy is what we call plain English. Sometimes people early on in their advocacy journey think that it's really impressive to use lots of complicated words, but actually, the truth is it's much better to just speak clearly using plain, simple English that's easy to understand and easy to follow. It has more impact. It makes what you're saying more persuasive if you just talk in simple, plain English. And it should, of course, be in a professional delivery style. So professional language, there shouldn't be any shortcuts with the language that you're using. How do you then speak? Well, we've got a few points here: pace and projection. When you're making your submissions or you're asking a question of a witness, you want to ensure that your delivery style is slow, clear, and easy to keep up with. We all often talk too fast. I'm very, very guilty of doing it. And I have to make a real effort when I'm in court to slow down, because otherwise, what I'm saying, people might miss something that's being said. They might not understand a really important point that you're trying to get across. And that then can lose the impact. So you want to speak slowly, almost to the point that it sometimes feels a little bit uncomfortably slow to you. But actually, if it feels uncomfortably slow to you, it's most probably coming out at about the right pace. You want to speak very clearly and at a pace that is easy for the person listening to keep up with. So, what do we mean by speaking clearly? Well, part of this is about the language that you use, your manner and your tone, but it's also about your projection. So, this is the volume that you're speaking at. It's the enunciation of the words. It's even the direction that your voice is traveling in. So, you really want to think about the room that you are in. Courtrooms are all very different shapes and sizes. And depending on your practice area or the court that you're in, you may be addressing lots of people, for example, a jury in a Crown Courts that could be quite large, or you may be in just a judge's chambers for, say, a small claims hearing. When there's only a couple of people, you may be on your own, just you and the judge. So you want to think about the projection of your voice according to the space that you're in. And if you are talking to somebody directly, for example, addressing the judge, you want to make sure you're directing your voice towards them. You also want to think about the volume at which you speak so that everybody can hear you clearly. And sometimes this involves speaking at a much higher volume than you might think feels comfortable. But generally speaking, if it feels like it's a little bit too high in volume, that most probably means it's about the right level and that everybody will be able to hear you. Delivery also involves trying to avoid something we call fillers. You may not have heard of that term before, but I've already put on the slide here some examples of fillers, and I'm sure you're familiar with these. These are noises that we all make as humans when we are perhaps thinking or filling some space or some silence. So these are things like or Lots of different people have different fillers. It's often difficult to avoid using fillers. We're all human, we all use them, but wherever possible, you want to try and minimize or avoid using fillers because it can distract from what you're saying in your advocacy. Another important point for delivery is eye contact. So if you are addressing somebody, such as the jury, you want to make good eye contact with them. or a witness, if you're asking questions of them, you want to be looking at them. It's respectful for a start. There's a little tip I want to tell you about if you are addressing the judge. Something somebody taught me, watching the judge's pen. So if the judge is making notes, keep an eye on them. If you are talking too fast, they're not going to be able to keep up. So keep an eye on their pen. If they're able to keep up with you, then that means that you're talking at about the correct pace. You don't want to be overly reliant on notes when it comes to advocacy. So if you do have any notes that you've made, you perhaps want to have them just as bullet points rather than a full script. Advocacy is never good if you just stand there and read out something like a script in front of you. This will come with practice, though. And finally, speaking in the first person. So generally, this is the way that we address, for example, a judge, rather than saying we think or we talking about your client, you would say it in the first person, I. And rather than I think that, a more formal professional way of saying that is I submit that. You're making a submission to the court. So a couple more points on delivery here. When you are in court, you need to think about something called modes of address. So this is basically identifying what who is in front of you. So what judge you are in front of, what level judge they are at, which courtroom you are in. Because depending on the type of judge that you're in front of will change the way that you address them. And I've put some examples there. That's not a full exhaustive list. So you might be referring to them as Your Honour, or it might be judge. So make sure you've got the correct mode of address. When you're introducing the representatives, it's common practice not to introduce yourself and say, my name is Beverley Dawes, but instead you introduce your opponent and then you explain who you both represent, so your parties. In terms of delivery, it's also very important to think about being consistent, especially in cases where there's lots of different people involved. It's not very helpful if at one point you're referring to somebody as the claimant, and then at the next point you're referring to them as the applicant, and then in the next breath you're referring to them by name. It can get quite confusing. So make sure you pick a standard naming convention and stick with it throughout. If you decide to refer to them as the claimant, call them the claimant throughout. It will make it much easier to follow. When you're referring to any documents in court, which you'll often have to do, try to be clear and helpful with your references. So for example, if there is a bundle, you want to refer to a document, refer to it by page number rather than just saying the witness statement of X. If you are referring to a witness statement and you want to perhaps refer to something that was said in it, refer to the paragraph number. This will make it much easier for people to find it. So it might be that you are directing a judge to something in the bundle. You would want to draw their attention as clearly as possible to the bundle, because otherwise they'll be fiddling through all their papers and really struggling to find what you're looking for. And finally, when you are responding to any judicial intervention, that's questions from the judge, take a moment to think about what you've been asked. And if you need a moment to think about your answer, that's completely fine. Don't rush your answer. If the judge asks you the question there and then, answer it. Sometimes people think, oh, I'm going to come back to that later. So they'll say that to the judge. Don't do that. If the judge asks you the question, deal with it there and then, and try and be clear and slow in your delivery in response to judicial intervention. So finally, just a couple of top tips from me regarding delivery before I hand over to Louise. So these are some tips to help you improve your delivery. Well, you won't be surprised to hear that practice is going to help you improve your delivery. So practice, practice, practice. It is an art form, and even barristers who've been in practice for many, many years still find ways to improve their advocacy. So it is a skill. Don't be afraid to practice it. One way you can improve your advocacy is by recording yourself. It is a little bit cringeworthy at first when you watch yourself back and hear yourself, but trust me, it is a really effective way to improve your advocacy. In terms of using notes, I've already advised that it's not a good idea to use a script, but often people who are starting out on their advocacy journey like to have a script. What you want to do, though, the more you practice, is try and move away from that script. So try and condense that script down to just bullet points or prompts. That will help you be more engaging, better eye contact, and not as rehearsed. It has more impact. Try to anticipate what the judge may ask you if they are going to ask you any questions of judicial intervention. You may feel a bit more prepared with your answers. You can't always guess everything, but it's a good idea to try and anticipate the kind of questions that might come your way. And finally, an excellent way to improve your delivery is to get involved with extracurricular activities. So things like mooting, mock trials, any sorts of in extracurricular activities where you'll be addressing people and doing public speaking is going to really help build your confidence and improve your delivery. So I hope you found that segment helpful. I'm now going to pass on to my colleague Louise, who's going to take you through some top tips on submissions-based advocacy. So Louise, over to you.
Thanks, Bev. Hi, everybody. Good evening. It's lovely to be here with you today. So I'm going to be covering submissions advocacy. Next slide, please, Bev. Thank you. So we're going to be focusing on structuring submissions and submissions-based advocacy. And I would not be making a very good start to a talk about the importance of structure if I were to not first set out the structure I'm going to use for this talk. So we're going to cover 4 things. First, what do I mean by submissions advocacy? Second, where to start when you're doing your advocacy, not overlooking the importance of case analysis, basically. Third, we're going to talk about skeleton arguments, which are a vital tool that we use to supplement our submissions advocacy. And lastly, we're going to come on to the big one, which is oral submissions. Next slide, please, Bev. Thank you. So, first of all, submissions advocacy. What do we mean? Well, we do not mean a trial. So you're going to hear from Nigel shortly, and he's going to tell you all about the fun that is cross-examination. But we don't do that in submissions advocacy. It's not a trial. And almost always, we don't have live witness evidence in submissions advocacy. So the judge has only written witness statements in front of them. And it's your job to make those written witness statements come to life and speak in the way you need them to get the judge on your side. So if it's not a trial, what are we talking about? Well, we're talking about applications, and they can be made at any point. They can be made before anybody's brought a claim, or perhaps someone's brought a claim, but you're making an application for something during those proceedings, often before trial, could be during the trial, or at the start of trial on the day. And we're talking about the sorts of things I've listed here on the slide. So summary judgment, for example. So this is where you think that your case is so good and the other side's case is so rubbish that the judge should be able to deal with it all now and save everybody the hassle and the cost and time of going to trial. So that's summary judgment. We could come back to that in a minute, so hold that thought. Might be a freezing injunction. So you might think the other side has lots of lovely assets that you would like to get or enforce against, but you're worried that they're going to try and hide these assets, maybe around the world or through complicated structures. So you might go and get a freezing injunction to freeze their assets and stop them doing it. Other examples, a disclosure application. Perhaps you think the other side has a really important document that they're keeping back from you. So you bring an application for them to provide it, or an application to amend. So Bev mentioned earlier that you would be studying on our course how to draft statements of case. These are the documents in which you set out for the court what your case is, or maybe what your defense is. But sometimes things go wrong. Maybe something new crops up, or maybe you made a mistake and you need to add something in. So that would be an application to amend. There's other things I haven't talked about on the list there, and the list goes on and on. There's all sorts of things. So it's a really varied bag. You could be asking for anything at all, basically, in summary. So moving on to the next slide, please. So where to start? You've just received a huge bundle of papers on our course or further down the line in practice. What on earth do you do? You've got your application tomorrow. How do you get prepared? Preparation is everything. That cannot be overstated. It's very tempting, I think, with advocacy sometimes to just want to get stuck into the fun of working out what to say to the judge. But if you do that, you're missing a crucial stage, and you might end up putting your client's interests at risk by overlooking something important. So we have to be very careful when we're preparing, as lawyers always. First thing to do, read your instructions. So this is the document you receive from your instructing solicitors telling you what you are being asked to do. So what the application is and what they want you to get at court. And then after your instructions, you'll have all of the case papers, and it could be very, very long in practice. You have to read every page of those case papers very carefully to make sure that you don't miss anything at all. Some people like to quickly scan through to get an overview and then go back through much more carefully. Others prefer to read very carefully right from the start. It's up to you, and you'll find your own way on the course or in practice, but you do have to look at every single page. Secondly, I've put chronologies. I am not in any way misleading you or overstating it by saying that every single case that I had in practice, I opened a Word document and prepared a document that had the heading chronology. And as I was reading through the papers, I put every single important, relevant date that I came across onto that document. I'm not exaggerating. I literally did it for every single case that I had. Some were very long. Some I would add to over a year or more as the case progressed. Others were very short, but they're very useful things, and they can help you get your head around things as you're reading into a case. You can also provide it to the judge and look wonderfully helpful in doing so. So you've read the instructions, you've maybe prepared a chronology. Where do you go next? Now you are beginning to think about where you're taking this. How are you going to get what you want? So you need to identify the issues. What do you actually need the judge to decide on for you to succeed in your application? And obviously, that's going to vary from case to case. And fourthly on here, we've got research. This kind of goes hand in hand with identifying issues. Sometimes if it's a very complicated case, you might find as you do your research, you need to revisit your issues, maybe add more in or take things out. And in this stage, you will be identifying the relevant legal tests, again, that you need to persuade the judge on in order to succeed. And submissions advocacy in civil law often turns on a test that you will find in the Civil Procedure Rules 1998. And if you were to join us on the bar course, these are rules that you will become extremely familiar with. Lovely big fat white books that we will take you through on the course. And I've given you an example on the slide. So this is the test for summary judgment, which I mentioned earlier. It is Rule 24.3 in Part 24 of the CPR. And this is where you're saying to the court, my case is so good, their case is so poor. Please give me what I want now. We don't need a trial. So this sets out the test that the judge has to be satisfied of in order to give you that order. And you'll see here that the judge may give summary judgment on the whole of a claim or an issue if A, it considers that the party has no real prospect of succeeding on the claim, defence or issue, and B, there is no other compelling reason why the case or issue should be disposed of at trial. So it's a two-part test. keep it in mind as we proceed to the next slide, please, Bev. So you've read your papers, you've done your research, you've analysed your case, you've worked through all the limbs of your claim, any relevant tests, you're good to go. Next, we need to prepare a skeleton argument. So this is your written document that is going to support your oral submissions in court. And it's also your chance to get in early and tell the judge in outline what you're going to be asking for and why you should get it. So it's your chance to start to persuade the judge as early as you can. They might read it the day before, perhaps, if they have time and are looking through the cases for the next day. So this needs to be punchy, effective, persuasive, and clear, all of these things. On the slide, you can see on the left there the recommended structure for a skeleton argument. This is sort of keeping it in broad terms. You'll see introduction, just telling the judge what it's about, what the application is, maybe highlighting some key information sometimes. Then you tell the judge what the evidence is that they've got to look at. You give a summary of the factual background. Then you set out the relevant law and issues that you've identified in your research. So that might include setting out a test from the CPR, the summary judgment test. Sometimes you might need to go further into substantive law. So if you're persuading the judge that you should have summary judgment on your claim, you might need to tell them some relevant law about your claim and why you say it's such a strong claim. So that goes there too. Along with, ideally, a very clear short list of what the issues are, just so that the judge has a clear picture. Then you get to the meaty bit of your skeleton argument, which is the submissions. We'll talk about how to structure those in a moment when we come on to oral submissions. And lastly, the conclusion, which should be making extremely clear to the judge exactly what it is that you are asking for. You definitely do not want the judge to put down your skeleton argument thinking, what do they want from me? A good skeleton should be clear in identifying the issues, as I've said. It should summarize arguments. That's why it's called a skeleton argument and why I put a picture of a skeleton there, just to hammer it home. It should not be super lengthy. It wants to be tight, short sentences, short paragraphs. Your opportunity to flesh it out is when you're speaking, just like I'm doing now with these slides. It should showcase your ability to cite authorities properly. And if you don't know how to do that now, don't worry. We would take you through that on the course. And it should have lots of lovely references to the case bundle so that the judge can dip in and find things if they want to look at something in preparation. Last point on this slide, your skeleton should support your oral submissions and not replace them. So Bev's already mentioned the importance of not reading a script. It's not the thing to do in advocacy. So you definitely don't want a long skeleton argument that you read to the judge. The second you start doing that, the judge will switch off. Why should they need to listen to you if they've got your skeleton argument already? So let's talk about oral submissions. Next slide, please, Bev. So we're getting down to business now. I've got, I think it's a total of 6 points here. So number one, introductions. Bev has taken you through the very first thing. You'll introduce your opponent and say who you both appear on behalf of. You're going to flag your what your application is, what you're asking for. And there's a checklist basically that you go through, which we provide you with on the course. But you're going to check the judge has got everything, the case papers, your skeleton. You also check that they've had a chance to read them, because it doesn't necessarily follow just because they've got them that they've read them. And this is important information for you, because you don't want to start talking assuming the judge knows about your case if they don't. You offer a summary of the background facts, which they may or may not want, and then you outline your submissions, which leads into point 2 here, headlining and signposting. So these are really key tools in your toolkit to use for oral submissions. And what do we mean by these? Headlining is setting out where you're going at the start of your submissions. So I might say, we're going to talk about oral submissions. I'm going to take you through, firstly, introductions. Secondly, headlining and signposting. Thirdly, how you go about choosing your order. That's headlining, setting it all out at the start so that the listener has a clear picture of where you're going. Signposting is what you do when you're moving to the next point. And it's good to be clear about where you are in your submissions, so that the judge or any listener can follow along. So headlining is what you're going to cover. Signposting, what are you talking about right now? To demonstrate, I'll move now to my third point. So how do you choose your order? So this is how do you actually structure what you're going to say, the content that you want to get across. Structure is very important. You absolutely just can't start speaking and say all of your points in a random order. It's very difficult to follow, and you risk not taking the judge with you through your best points. So you've got to think about it before. There's not necessarily a right structure for any given application. There's no one size fits all. Sometimes there is, but often not. It's down to you, and you need to think carefully about what's going to A, make the most sense, and B, have the most impact, because you are there to persuade the judge. Sometimes a chronological order is best. If it's a very complicated claim, lots of things have happened all over the place, maybe go through your issues in chronological order. Often it's best to follow the limbs of a legal test. We've got the test for summary judgment there again, so it would make sense. Why not have your first submission on limb A, saying that the other side has no real prospect of succeeding on their claim or defence, and then the second limb, B, address why there's no other compelling reason why it should go to trial. And lastly, on ordering your points, this might be contrary to what you might think, but almost always it's best to put your best point first. Often I think people have this idea that it's best to save it in reserve, and you'll go through some points and then towards the end you hit them with your best point, so that you'll get them on side then. It's risky business, that, because what if you lose them at the start? And you're kind of sending a message to the listener by putting that point at the end that it's not so important. So the point that you think is the best ends up being lost on the listener after all. So best point first, usually. Okay, next slide, please, Bev. So some final points now on oral submissions. Making the submissions themselves. So we've headlined and signposted. We thought about the order we're going to put them in. How do you actually make the submissions? Well, I've given you a little structure on the right there. The order is your submission, by which we mean what is the point that you're making now, in not too many words, not in high levels of detail. What is the headline submission that you're making? Then take the judge to the evidence for that point, get them to turn there, give them page number, paragraph number, as Bev said earlier, show them that evidence, then explain why it supports the point you're making, tell them the legal consequence. Accordingly, judge, as this evidence demonstrates, the defence has no real prospect of succeeding on this point. And then a mini conclusion, say what your final submission is. That little structure will serve you well in any submissions advocacy. It's a tried and tested formula. And it leads into number 5 here, using the bundle, so using the evidence. It's a common mistake that people will describe in great detail what it is that the evidence shows and why it's helpful for their case. And then just say in passing, Judge, you'll find this on page 23 of the bundle. You want to do it the other way around. Take the judge to the evidence first, get them to see it, and then explain why you say it's important. So I've said, show, not tell on the slide. You want the evidence to do the talking, and you want the judge to see the evidence so that it has that impact. Lastly, conclusions, not to be forgotten. People often downplay the importance of a good conclusion. If you've done your work well in your submissions, everything should be leading to this point. So don't miss the opportunity to hammer it home. You need to be clear in what you're asking for. End by saying exactly what order you want the judge to make. Judge, for the reasons I have set out, I say that summary judgment should be granted today, and the claim should be dismissed summarily today. Be 100% clear, no doubt. And then you're going to summarize your reasons. So it's revisiting your submissions that you've made, just in brief, all working towards the final point, which is you should be granted what you want. And I'll end by saying that, as Bev said, it's all about practice with advocacy. You will have lots of opportunities to practice advocacy if you join us on the BPC, and we'll revisit some of the points that I've just taken you through. Thanks, Bev. No, not Bev. I'm handing over to Nigel.
Thank you very much, Louise. All right, so cross-examination. So this is something that I teach on the course. And when I begin in September with the new intake of students, it'll be my 7th year teaching criminal skills. And if we move to the next slide, you can see an image of a book that I've written with a silk that's coming out in November. And I'm asking you, do not buy this book. Don't buy it. 2 reasons. Firstly, it isn't out yet. And secondly, if you come and study with us at the University of Law on the bar practice course, you don't need this book anyway, because we teach you everything you need to know to pass the exams. But the reason why I've just put the book here is because in it, we have a fictional set of case papers that we revisit throughout. And I'm going to take you to some of those papers. And you'll see, for instance, on the next slide, that the fictional set of case papers we have is for someone called Tegan Plant. And moving on, you'll see here the instructions to counsel. We have a defense version as well. But here you can see that Tegan Plant is charged with 2 offences, the main one being attempted robbery. And the allegation is that he's gone with someone else in a car, stopped abruptly outside a bank. He's run inside and he's tried to rob it rather ineptly. Doesn't succeed, which is why it's an attempt. And he's then identified later at an identification procedure by the lady who worked in the bank. Why am I telling you all this? Because we're talking about how to cross-examine, aren't we here? Why are we talking about this case? And it's because you can't learn advocacy. You can't learn cross-examination, rather, in a vacuum. I can tell you the principles, but we're going to just put a bit of detail on it so that you can understand how we craft a cross-examination. And if we move to the next page, you're going to see that the main eyewitness to the arrival of the robbers is a man called William Hawkins. And I've included here a couple of excerpts from his witness statement. And I put some red boxes around the parts to save you the time of having to read everything. Well, what William Hawkins says is that he was about 30 meters away from the car when it stopped. It was difficult to see the registration number because at the time it was snowing very heavily. But the last part of the registration was definitely XCM, and the car was white and had 2 doors, and it was a Renault Clio. And on our next slide, I'm racing through this a bit, but you'll see why. You see that on the morning of the attempted robbery, so before the robbery took place, someone stole a Renault Clio, and it was a car with 4 doors. You see the registration number ended XCM, but it was light green, and it had 2 rear doors that were blue. The thing is, the next day, when that was found burnt out, Tegan Plant's DNA was found on the inside front passenger door handle. So let's see what Tegan Plant says about this. And on the next slide, we're going to see this. Again, no need to read it all, but that first red box is taken from the defense statement that he submitted in this case, in which he sets out his defense. And it's a defensive alibi. He was never there, never in the car, never went in the bank, wasn't the man who tried to rob Isabel Olger. Instead, he was at a pub called the Swaggering Duck with a friend called Thomas Ellington Edge. And about the DNA, well, maybe the DNA is mine. I mean, I do remember, he says, that a green car pulled up alongside me that day, and a friend was in it, although I can't now remember who that friend was. And I did touch the car, so maybe that's the car that you found, and that's my explanation for my DNA being there. It's not the case, Tegan Plant is saying, that the fingerprints are there because I was in the car when it pulled up outside the bank for the robber to jump out. Innocent explanation. So on next slide. So we'd have a bit of a brainstorm. We'd imagine we're defending Tegan Plant, and we'll ask ourselves, what do we notice about the facts so far? And we're asking ourselves whether Mr. Hawkins' evidence will help the prosecution prove their case. And why are we doing all of this? For exactly the reason that Louise was talking about a few minutes ago. This is what we call case analysis. And you cannot put together legal submissions in a civil case or cross-examination in a criminal case without noticing things about the facts and understanding what's going on and having a target to aim for. You can't start your preparation by writing the questions out. You've got to start by understanding the case and knowing where you want to go with it. So hopefully, if we just pause here for a moment, you'll have noticed that according to the eyewitness, Mr. Hawkins, the Renault Clio was white that he saw, and that it had 2 doors, whereas the car that was stolen, that the prosecution are saying was the car used by the robbers, was green, but the 2 rear doors were blue, so not matching at all. Although, curiously, the registration number, Mr. Hawkins is right about that, isn't he? So let's move on to our next slide. Just going to hold that thought and see where we go with things. Because what we're going to talk about in this cross-examination section is these 7 topics. How does a court decide whether to accept a witness's evidence? And we'll see on the next slide that there are really 3 questions that the court asks itself about a witness's evidence. Having heard the witness give evidence and be cross-examined, do we think the witness is honest, for a start? Do we think the witness is accurate in what they say? And do we think that they're reliable? So they're the first 3 questions before the court even draws any sensible conclusions about whether to accept what the witness says. And very often having the witness right in front of you in the courtroom answering the questions is a really good way for the jury here to see if the witness is honest, accurate, and reliable. Just like you might do in ordinary life when you're meeting someone and you're asking yourselves whether you can accept what they're saying. So in a sense, this part of the criminal trial isn't much different than what we do in life anyway. And I guess that's the point of the jury system, isn't it? And on our next slide, we'll see how difficult that can be in the context of our case against Tegan Plant. Because what does our client say? It wasn't there. Never went in the bank. So in a way, we want the witness to be unreliable, don't we, about his note XCM? Because if the witness is unreliable about that, then that car that was found with the registration number XCM can't be linked to the client, can it? But the difficulty is we want the witness to be reliable when he said the car was green and had 2 doors, because we know that the car that was found burnt out was white and had 4 doors, and 2 of them were blue. How can you have it both ways, that the witness is reliable and unreliable? So these are the sorts of challenges that we're thinking about when we're deciding how to cross-examine this man, Mr. Hawkins. And if we move to our next slide, I'm going to surprise Louise, actually, by thinking about possible cross-examination and asking Louise if she can be the witness and answer these questions. Now, you weren't expecting this, Louise, I know, so it's a bit unfair. Are you up to the challenge?
Am I able to see what I'm supposed to know?
Well,
I could try.
your task is to answer yes to every question, but no to the last question.
I can handle that, Nigel.
So you're Mr. Hawkins. No, Mr. Hawkins, you saw the car come to a stop, didn't you?
Yeah.
It stopped outside the bank.
Yep.
You were only 30 meters away from the car when it stopped, weren't you?
Yeah, I was.
You observed that the car had 2 doors, isn't that right?
Yep.
Your evidence is the car was white, isn't it?
It was white, yeah.
You say the registration number ended XCM, don't you?
Yeah, I do.
But you accept the snow was falling heavily at the time.
It was.
And that it was difficult for you to see the fine detail of the letters.
Yeah.
Could your note of the registration number contain an accidental error?
No.
Thank you, Louise. So let's go on to our next slide, and we'll see the pattern. So that cross-examination was designed looking at Mr. Hawkins' witness statement and anticipating what he'll tell the jury when the prosecutor is getting his story out of him. And then we go next to cross-examine him, and we're establishing an important pattern here. We're getting Mr. Hawkins to say yes to pretty much everything, except that last thing. And maybe we'll strike lucky and the witness at the end will actually agree that his note could be accidentally mistaken, but probably not. But the point here for cross-examination, and this is part of the cross-examination course that we teach, we're creating a pattern here, and the atmosphere is that the answer is always yes. So when the answer no eventually comes, and we know it will come, it doesn't seem right to the jury. And this style of questioning casts doubt on the accuracy and reliability of the witness. And we'll remember from before, don't we, that accuracy and reliability are 2 of the main questions that the court will ask itself when deciding whether to accept Mr. Hawkins is not exactly being truthful, because we're not saying he's being deliberately dishonest here, are we? He just happened to be outside the bank and saw this thing happen. But all those features we spot here allow us to cast doubt on the accuracy of his identification of the number. All right, so hang on with me. We're going to go to the next slide now, which is about the aims when cross-examining a witness. And this comes down to case analysis, pure and simple. We have to know what our case is about Mr. Hawkins. Note, one of the questions we asked him was, could your note contain an accidental error? We didn't frame the question this way. Your note of the registration number was wrong, wasn't it? And there's an important reason why we went for one option and not the other. That's because our client was never there. So he doesn't know about the car that pulled up. This is what he's telling us in his instructions. He doesn't know what color the car was. He doesn't know if it had 2 doors or 4 doors. He doesn't know the description of the man who went in the bank because that wasn't him. He doesn't know anything about what went on. So we've actually got no basis for saying to Mr. Hawkins that his note was wrong. We can't put that because that's not our case. But we can test the evidence. So our instructions allow us to ask the question whether his note contained an accidental error. Of course, if things were different, you know, if our client's case was, I was in the car, I did pull up, I did jump out, I did go in the bank, but in no way did I threaten Isabel Olger. All I did was ask if I could withdraw £20 from my account. I don't know why she's saying any of that. Well then, perhaps the way we approach Mr. Hawkins would be different. And that's the importance of case analysis. You have to know what your case is in order to know how to cross-examine. And that's part of what we teach you on this course. It so happens that Mr. Hawkins is just a device which allows us to have a look at that today. So that's our second point here, the aims when cross-examining. Let's move on to our third point, which I've termed attack, 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 because very often people think cross-examination is where you go in, you know, with your weapons, firing away, shooting, and it's all about destroying the witness. Like I say here, if it was a boxing match, this is when you knock out the other side, but it's really not like that at all. I don't think I've ever approached a cross-examination in all the 20-odd years I was prosecuting and defending in that way. What you've got to do in the main is listen to the witness and react to them. So you've got a strategy, and the strategy we saw on the point of the registration number was seen in those questions a couple of slides ago. But you hardly ever win a case by forcing the witness to say, yes, Mr. Booth, you're right. You've got me. It's a fair cop. I was making it up, or I was completely wrong. That never happens. Can I tell you, when prosecuting, only once in my career have I ever had a defendant who I was cross-examining admit the offence to me. And he didn't know he was admitting it. So he wasn't intending to. It was just luck, really, rather than skill that brought out that admission. But the point is, attack, attack, attack is never, or no, never say never, hardly ever the right approach. You get the witness to agree, and then you put the controversial point and they deny it. But the point is no one believes it because of the way you've structured your questions. So we can see on the next slide the fourth point, if you like, of cross-examination, putting the case. And that's a phrase that criminal lawyers use all the time, and it's not obvious what it means. All it means is you must give the witness who you're cross-examining the opportunity to answer what your client says about the case. So if you look at Isabel Olger then, so she's the lady in the bank who was faced, she says, with this man who was trying to rob her. And then a couple of days later, she goes to an identification procedure at the police station, lineup of people, points to Tegan Plant and says, I recognize him. He's the man who came in the bank. So we have to put our case to Isabel Olger. And we're very unlikely to be saying that there was something wrong with the identification procedure. So we wouldn't really be asking about that. But we do need to put to her that she's wrong in identifying our client. Because our case is, our client was not the man who went in the bank. And so she's wrong to say that he was. So definitely, to put our case, we must be very clear with Isabel Olger that she is wrong about that identification. So putting your case is a really important part of cross-examination. Okay, our next slide brings us to point 5 in my agenda, which is leading questions. And what we teach on the course is that in a cross-examination, you must always ask leading questions, without exception. Now, in real life, when you graduate from the bar course and you go into practice, it's up to you. You might choose sometimes not to ask leading questions. That's fine. They're your professional decisions. But on the course, learn this approach to questioning. And what is a leading question? A leading question gives the witness the chance only to answer yes or no. So the point of cross-examination is this: you never seek information from the witness, ever. You never ask the witness to tell you about something. You do not give the witness the platform to give an account. No. Your questions are always designed to be answered very simply, yes or no. So here's a little reproduction of our questions, Mr. Hawkins. Now, we know that he's got to answer yes to all of those, because actually, although I didn't put all of Mr. Hawkins' witness statement on the screen, this is all in his witness statement. So I know he's going to answer yes. And that is what, in the book, we give it a kind of mathematical equation. You're making a statement. You saw the car come to a stop with an affirming question, didn't you? And that gives us, the questioner, control. And the witness is now controlled to answer the precise question that we're asking. So that is how to ask leading questions, which is a really fundamental part of learning the skill of cross-examination. So our next slide then brings us to number 6, which is how to build up your questioning. And I can only really demonstrate what I mean here by showing you a no build-up and a build-up and contrasting them. So here it is with no build-up, and we're imagining that you're now cross-examining Isabel Olger. And we'll imagine that the question is, when you identified the man at the identification procedure as being the man who came in the bank, you were mistaken, weren't you? Now, yeah, in this example, the witness answers, no, I was not. And in a real world, that is the answer you will expect Isabel Olger to give you. This isn't a boxing match like we talked about earlier, where the witness is suddenly going to crumble and say, yes, you're right, it wasn't, I've made a terrible mistake. That's never going to happen. But if you put your question like this, with no build-up, it has no effect. Whereas, if we look at our next slide, and then we'll see we'll move on to the one afterwards straight away, here it is slightly differently. And we imagine, Louise, could you be the witness again for me? You did it so well last time.
I was hoping you might say that, Nigel.
Oh, yes. So, Miss Olger, what the man did in the bank was completely unexpected, wasn't it?
Yeah.
And quite frightening.
It was very, yes.
When the man stood in front of you at your counter position, he said he had a weapon, didn't he?
Yes.
And he threatened you with violence.
He did, yeah.
You must have been terrified.
I was, yes.
And carrying on the next slide. His mask had become a little dislodged.
Yes.
Nonetheless, it still covered a lot of his face.
Yep. Yeah.
His eyes were exposed.
Yeah, they were.
Though after the event, you were unable to say what colour his eyes were.
That's right. Yeah.
The man was only in front of you, wasn't he, for a matter of seconds, after all?
Yeah.
And when you identified the man at the identification procedure as being the man who came in the bank, you were mistaken, weren't you?
No, I wasn't.
Okay, thank you very much, Louise. So you can see here the point I'm making, which is when you give the build-up, I mean, you're going to get that answer to question 11 all the time from the witness every day of the week. You were mistaken, weren't you? No, I wasn't. But do you see the strategy of the questioning here? And it's typical of what we teach on the course. You're building up to that conclusion so that when you get the inevitable answer from the witness, no, I wasn't mistaken, you've already sown the seeds of doubt in the build-up questions. So that's an example of one of the aspects of cross-examination that we teach. Now, if we move on to the last slide, which is our 7th point about cross-examination, golden rules. And you speak to almost any advocate and you say, what are the golden rules for cross-examination? It's a fair bet they'll all say these two. Never ask a question too far. And what that rule is getting at is you've got to you're in the moment asking the questions, but you've also at the same time got to be above looking down. And you've got to know when you've got what you need and force yourself to stop. Because it's the overconfident barrister who's getting the right results from the right questions that they're asking, who thinks, oh, I'll just put the cherry on the top of the cake and just do this extra bit. And then the witness completely demolishes you. So always be alive to the need, don't ask a question too far. And the second one is never ask a question to which you do not know the answer. And that's very fair in cross-examination. We've already talked about how the questions really are built up using information that the witness has already given. All right, so that is the end of the cross-examination segment today. By no means is this everything we teach you in cross-examination on the course, but it's a good demonstration of the main aspects of the course, and it's enormous fun. Students do enjoy cross-examination. So thank you very much for listening, and I think I'm handing over to Helen to talk about mooting. Thank you, Helen.
Thank you, Nigel. And I must admit, I find teaching cross-examination one of my favourite activities as much as doing cross-examination. So hello, everybody. I am Helen Carter and I sit in the Bristol campus of the University of Law, but I also oversee Oxford. I'm going to briefly talk to you about mooting. I'm spoilt by the others. I don't need to say as much because actually they've covered some of the things that I might have said if I was just talking by myself about mooting. So the first slide about mooting is thinking about what a moot is and what a moot is not. And I'm hoping that those of you who are still wide awake will have noticed that some of the features of mooting are very similar to submissions advocacy. Let me explain why that is. It's because a moot is a role play appeal. And because it's an appeal, the people who are making their submissions are thinking about points of law and that a trial has happened and somebody does not agree with the outcome as a point of law. And because there are therefore no witnesses and no jury, and you're not really talking about the facts being wrong, more that the facts were wrongly applied in law, it feels much more like submissions advocacy. That is not to say that a moot is only about civil law. You can have a criminal law moot as well. But what we're thinking about is very much sort of academic law in a way. I really used to enjoy mooting as a student because it was like the sport of academic law, talking your way into the winning team. You generally go in pairs so that there's a senior and a junior member for the appellant and a senior and a junior member for the respondent. I have managed moots with 5 people before where I had somebody introduce the points of fact, but usually in competition mooting, it's 4. It's not a bad thing to be the senior or the junior. It's just it helps people to understand which ground of appeal they're working on. Because when you first receive your mooting problem, it will have at the top of the page a scenario, which is the facts of the trial as decided by the trial judge. And then it will have underneath that what the outcome of the trial was in accordance with that trial judge. And then it will have 2 grounds of appeal. And so these 2 people simply have 1 ground each, and we call them the senior and the junior. The senior will do the first ground of appeal, the junior will do the second. And if you're working for the appellant, you're trying to agree with the ground of appeal and say that the previous judge was wrong. If you're working for the respondent, you're trying to disagree with the ground of appeal and say that the previous judge was correct. So it's not facts, it's not witness handling, and also, quite importantly, it's not dramatic. Because actually, although it's completely fictitious and it's a role play, we are trying very much to pretend that we are real barristers in an appeal situation. And it reaches back to something that both Bev and Louise have said before: practice makes perfect. And so it gives us the opportunity to think about how we would research our submissions, how we would structure them, all sorts of different things. And it's a really safe way of starting to understand yourself as an advocate. So my next slide, in fact, my next 2 slides are based upon headings which might be things that you are assessed against if you are in a mooting competition. So I used the headings from the competition that I run within the Bristol campus, so that I think about these different headings when I'm trying to give one of the mooters their scores. So one of the headings is legal research. And my top tip for legal research, when you're first picking up your moot question, you've got those facts, that's the factual matrix, it's stuck like that, you can't add or take any facts in or out, but you're going to look at that, then you're going to look at the grounds of appeal, and you're going to start to think, well, where's this law come from? I would start big. In the ground of appeal, there is highly likely to be the name of a case. Start there. That case is important and should be within your written and spoken submissions. But the other start big place you can go to is a practitioner textbook or a very high quality academic textbook on the same subject. So let's imagine your mooting question is about contract law. My little hands go straight to the book called Chitty on contract. But you might prefer to do the same kind of research online, and you can find that same book reproduced online. So start with the obvious key texts, because they always tell you what the most important case is. Then you can actually start to look at those cases, use the head note of the case to check whether you think it's actually going to be useful and relevant before reading into the case to see if you can find something in that case that you'd like to say out loud in your moot that's really going to help your cause. You can also use cases to find more cases. This is particularly easy to do on big websites like Lexis Library and Westlaw. Within a case, there'll always be somewhere that you can click on the screen that says cases citing this case, cases following this case, and so on, to find more cases. The really big top tip about legal research to mooting is you're not necessarily going to win because you found the world's most obscure case. So try and stick with the big hitters and find a really good citation, a piece of it to quote that you can apply to the facts and then persuade your audience, which is the judge, to go in your favour. Presentation is another very common heading to be assessed against in a moot, and you've heard loads of really useful information already from Beverley. But the one thing I would say about presentation in mooting, because it is quite academic, it is quite formulaic, is for each point of law that you want to make, start by identifying the issue. So we were thinking, what if it was a contract case? Or what if the issue is that the offer in the contract was not accepted? That's what you would say at the beginning of that submission. It's my submission that the offer in this contract was not accepted. And then you could go on to the rule. The rule is that there is no such thing as acceptance by silence. And then you could give a legal authority. You might put the key authority, or if there's one that specifically matches the kind of non-acceptance that you're talking about in your scenario, you might want to use that authority. And then you can go on to say, and following that authority, I'm saying that there was no acceptance because this person remained silent throughout. That makes a nice, tidy submission. If you do it one point of law at a time, you're going to do very well on presentation. But do remember the other things that Bev has just said, such as talking slowly and clearly, and perhaps talking more slowly than you'd like to. Then you will be asked to provide a bundle of authorities. I think Louise has done a very good job on this, but she said show, not tell. I've called it show and tell, but it's actually the same point. It is if your judge is looking at the law written down in front of them because you've printed out a segment from the relevant case. They are reading the law as you are talking about the law, as you are applying the law, and they have to say, well, I can't fault that. That must be correct because I'm seeing it, I'm hearing it, it's being related to the facts of the original trial. This must be true. The next heading on the next slide then is thinking about the structure. And there are again some real overlaps here. We obviously have all learnt to do advocacy the same way, which goes to show that there is generally only one really good way to do submissions advocacy. Make your best points early. I always joke that if you were to be in a real appeal and your first point was a winner, everybody could go home early. And that's actually true. We don't want to leave the best point till last. You might have lost the judge's attention. You might run out of time in a moot. You're usually got a clock. There's usually 10 or maybe 12 minutes to speak. So you want to get that real killer point in straight away. And if you have any policy points, perhaps you're mooting in a fictitious scenario where you're in the Supreme Court and you might try to persuade the judge to actually change the law, you still need to leave that till last, because that is policy. It's not actually applying or distinguishing the cases that already exist. It's best that your structure aligns directly with the grounds of appeal. So in particular, the senior must take the senior ground and the junior must take the junior ground, and try not to delve into each other's submissions because they will be discrete. And then finally, the structure can be used to follow the skeleton argument, and you can do some of the signposting recommended earlier. You can start by having a brief introduction as to what your points are going to be. And then as you say each submission, signposting as to I am now at point 1 on my skeleton argument, where I will be submitting that the offer was not accepted due to silence. And then if you want to make a second or a third submission, you need to say additionally, because it's adding to the first submission. Or it might be that you think the first submission might not be accepted, and you can signpost by saying, in the alternative to my first submission, if it's not accepted, at point 2 on my skeleton argument, I will be arguing that the offer was rejected in good time. So signposting before you start each part of your submissions is really helpful to the judge to see where they are at in the sort of the feel and the scheme of things, so that when you get to your conclusion, it's clear that that is just summarizing the 3 key points that you made. Etiquette is almost always assessed as part of a mooting competition, and I really think the best way to learn it is to go to court and watch it. In court, we do talk in a very formal way. We do strange things like we bow at each other. We don't stand up unless the judge is stood up. All sorts of things like that feel slightly old-fashioned, but I actually think that the formal way of doing things makes sure that everybody takes the situation quite seriously. So going along to court, whether it be Crown Court, whether it be a court of appeal, any court, you can start to learn the etiquette. But there's also an array of books and websites that are available. If you join us on our BPC, you will have access to a law library, which is huge online and includes access to a lot of Oxford University publications, where you will find some really good books on court etiquette and mooting. And then finally, as you go into more complicated mooting competitions, maybe not so much if you're doing a starter session, but later on, once you've got the hang of mooting, you might find that the judge starts to intervene. They jump in when you're talking. It seems rude, but they're in charge, and they ask you a question. The best thing to do in answer to that question is, as Bev said, don't put them off, answer it straight away. But if you can take them to the law in your bundle, so you could say, I'm grateful for that question, my lady. Let's go back to page 7 of the bundle where you can see the case of. And you tell them on the law what the answer to their question is. We're going back to that idea of showing and telling, aren't we? We're saying, look, I know the answer, and here it is in black and white in the law. I am correct. And the other really important thing is, however sticky a situation of questions you get from your moot judge, stick to your case. Don't concede anything, otherwise you've basically given in. So those are my top tips for mooting. I'm very happy to take further questions, or you will certainly have the opportunity to do some mooting with us if you come along and join in with ULaw. I'm handing back to Bev now to conclude.
Thank you very much, Helen. So thank you to all of my co-speakers for delivering their segments today, and to all of the students who are hopefully still with us on this call. We do hope you found that to be informative, useful, and giving you lots of ideas for advocacy moving forwards. So that brings us to the end of the presentation, and we'll be opening the floor up to any questions that you have. So if there's anything you'd like to ask us regarding the University of Law, the BPC programs that we offer, or anything regarding advocacy from our presentations, then please do let us know. And thank you so much once again for attending, and we hope you've enjoyed that session. I'll stop sharing my screen now.